Thank you for tuning to the special edition of the RENSHAW Report. Murray I, reporting from the city too tough to die, New London. I want to thank our friend John Leahy for arranging this meeting and my introduction to my guest today, who is Jose Rojas. Jose is an attorney. He's got quite an extensive resume here, some of which I can't read the names or pronounce them, but I'll try to get through it as best I can because it's very impressive. Jose went to law school in Connecticut, and just from the beginning into his law career, on May 26, 2022, Chief Judge Rebecca Palomir appointed Jose Rojas to the National Co-Lead Counsel of MDL 3026, Preterm Infant Nutrition Products Liability Litigation, very important to all of us, especially the kids. The appointment was followed by a 25-year career as a trial lawyer. Jose graduated from law school in 1997. Following law school, he was recruited and commissioned as a first lieutenant by the United States Army, Judge Advocate General's Corporation, known as JAG, and was swiftly promoted to captain 7 months later. Later, Jose was appointed to Special Assistant United States Attorney and was entrusted with the awesome responsibility of representing the United States as a federal prosecutor. He prosecuted and tried cases such as rape, child molestation, homicide, and larceny. Mr. Rojas quickly earned the respect of his superiors, who described him in the Office of Evaluation Report as the best, most aggressive prosecutor in this very busy legal office. Before leaving public service, Jose was awarded a certificate of appreciation from the director of the FBI for his outstanding prosecutive skills, and was made an honorary agent with the Army Criminal Investigation Division. They need you there now. Beginning in 2000, Jose spent the next 5 years representing large corporate and governmental clients at one of Connecticut's largest and most prominent firms. His work at this law firm focused on complex civil litigation with an important focus on product liability. In 2005, Jose switched sides and never looked back. Fed up of representing big industry and big government and driven by a desire to represent real people, Jose founded his own firm. He was handling cases involving personal injury, medical malpractice, and defective products, frequently taking cases to verdict. In 2020, Jose and his partners formed Levin, Rojas, Commissar, and Rec LLC. The firm was formed after founding what is now known as MDL 3026, Preterm Infant Nutrition Products Liability Litigation. But before the litigation achieved national prominence, Jose and his partners litigated the cases alone for well over a year. The early success Mr. Rojas and his partners achieved in the litigation was the foundation for what would later become one of the most significant mass torts in the country. Jose has been featured and quoted in numerous news outlets, including the Evening News, NBC 30, the Connecticut Law Tribune, the Hartford Courant, and the AAJ's Trial Magazine. Mr. Rojas has been asked to speak at important national conferences, including the American Association for Justice Convention, Mass Tort Made Perfect, National Trial Lawyers Summit, and various seminars and conferences for the Connecticut Trial Lawyers Association. Jose was rated AV Preeminent by Maritime Hubble, Superb by AVO, 9.9 out of a 10 rating, National Trial Lawyers Top 100, and has been repeatedly recognized as a super lawyer by superlawyer.com. And since I met Jose, I've developed a feeling of confidence and very comfortable speaking with him. Although you look like you should be a baseball player, not an attorney. In addition, for something that I won't mention today, I can't thank you enough for helping out some friends who we'll talk about at a later date, because that means more than anything, and also being friends with John Leahy, who's a tremendous advocate and friend. So welcome to the show, Jose.
Thank you, Murray, and to your audience.
Now, you mentioned somewhere in here that your type of law is not tort reform, but Connecticut, or mass tort reform. Boy, I screwed that up early.
Well, so
what are we talking about? We're not talking about Massachusetts.
No. So what my firm specializes in is mass torts. Mass torts are a type of lawsuit that involves a large group of litigants. Whenever there's something that happens to people, and it happens repeatedly over and over and over again, those folks collectively file, essentially, it becomes a collective lawsuit. So some examples of that are the Zantac litigation as an example, Roundup. You have products that are causing harm. The tobacco litigation was a mass tort. So you have a product that causes a harm, that same harm happens to a lot of different people, and rather than bring thousands of individual cases throughout the country, they get consolidated under one roof. And so a lot of people mix the terms class action with mass tort. It's a little bit different. Class action are those situations like when, a bank is charging fees and those fees are too high. They're illegal. Those are class actions. When someone is actually injured by a product, but the reason for the injury it applies to the claimants in very similar ways, we bring what are called mass torts. And you heard the term MDL there. They typically get consolidated under the roof of one federal judge, and the cases are handled for discovery under that roof, and eventually will need to be tried in what are called bellwether trials. So that's essentially a mass tort. What's interesting and unique is that there's a lot of firms across the country that handle mass torts, but to my knowledge, we're the only firm in the state of Connecticut that really does mass torts right here at home in Connecticut.
Where's your firm located, Jose?
We have an office in North Stonington, and we have an office in Hartford.
And what's the process for one of your customers who's involved in this mass tort litigation? Is that strictly a federal level type of deal, and what's involved with getting it from point A to point B?
Sure. So the first thing is a person needs to recognize that they're part of this, we'll call it a class, for lack of a better word. It's the easiest way to think about it. But you've been harmed in a certain way. So I know we're going to be talking about Camp Lejeune in a moment. But imagine that you know that you are part of a group of people that's been harmed by a particular product or a particular toxic hazard, an environmental hazard. Then the first step would be to call a lawyer and have that lawyer assess the case to see if it meets the criteria of that particular litigation. Sometimes a person will be the very first case that gets started. In other words, no one else has yet filed one. That's very rare. We did it here in Connecticut, and we're going to talk about that with the infant formula stuff. But in that litigation, we were the very first case that ever got filed in the country, and it later became a mass tort. So the way that began, which is a very unique situation, is we had one client come to us, told us about a situation, we looked into it, we did the research, and the next thing you knew, we filed the lawsuit right here in Connecticut. And then after that, we filed a second lawsuit, and then a third, and a fourth, and a fifth, and so on. And eventually, it caught the attention of some other big lawyers across the country, and they started filing cases all over the country, and then they got consolidated as a mass tort. So that's essentially the process from the very beginning. Once it becomes an MDL, or a mass tort, an official mass tort, then it's just a question of there'll be certain criteria. In other words, a person realizes that they've been hurt or injured by either a particular product or particular toxic hazard, environmental hazard, and then they just sign up for the class, basically. There's not a whole lot of work that goes into it from the client's perspective, because a lot of the work at that point has already been done. Sort of the initial, all the groundbreaking, the fights that we have to do in court to get the thing going and get it consolidated. When a tort is more mature, a lot of that hard work those battles have already been fought.
And are the cases determined by A judge or a jury?
In a way, both. So there's this thing called Daubert, which is a legal standard that the judge would decide. And Daubert means that before a lawyer can advance a case, we can't just make it up. You know, we have to base these cases on real science, hard data that we have to be able to support through experts and studies and things like that. So the judge, as a preliminary matter, acts as a gatekeeper in the litigation, meaning that junk cases don't make it to a jury. And there's been a lot of talk, and that you talked about, you know, the tort reform stuff. A lot of that tort reform has actually been driven by the insurance industry and big money that wants to keep lawyers out of their business for reasons we'll talk about more in a bit. But the reality is corporations do a lot of bad stuff, and so does government. And when they make a mistake, when they harm people, they try to hide it. And that's why these lawsuits are so important, because if it's not for lawyers bringing them to the attention of the public, and I can give you example after example after example, they get shoved under the rug, and the people never find out about the harms that are being caused to the communities. But in essence, what we have, and the reason tort reform, in my personal opinion, is a bit of a misnomer, if you will, is because there are so many gatekeeping functions before a case can ever even make it to a jury. You have to survive a motion to dismiss, which a judge rules on. A motion to dismiss is when the court says that you haven't even alleged a proper case. In other words, you don't even get past the original thing. Then you have to survive Daubert, which I've talked about, which is the scientific validity of your assertions. Then you have to survive a motion for summary judgment. The judge will rule on that as well. A motion for summary judgment means that we've produced enough evidence to justify the cause of action. And then finally, once you've made it through all those hurdles, you get to put your case on in front of a jury of our peers. You know, folks who hear all the evidence, and they decide whether they think that the allegations you've made, the claims you've made, which in these types of cases is usually that someone either has a product or an environment which is causing very serious injuries to folks or disease. And then the jury decides that if in fact that product or condition caused those injuries and diseases. And that basically brings you to the end of a case.
So in your experience, does a jury usually make the right decision?
That's a great question, Murray. I've been doing this for 25 years plus. And you know, when I'm in a case, I always think I'm right. You know, I only take cases I believe in. So I bring it all the way through, but sometimes you can believe your own stuff. And I can tell you that in retrospect, as I look on cases that I've lost in my career, I probably should have lost them. You know, at the time I didn't think it, but I think the jury made the right decision. And the cases that I've won, I really think were righteous. I think the jury made the right decision. I think our system is outstanding because what it does is it has two main components, really three. You have the gatekeeper function of the judge. You have the adversarial system, meaning that you have two competent lawyers who are presenting two different sides of a coin, right? And then you have a jury made up of regular people, sometimes 12, depending what jurisdiction it is, who have to basically sit in a room, look each other in the eye, look at the evidence, and conclude whether this side's right or this side's right. And yeah, I really do think they get it right most of the time. Because they're just six common sense folks looking at it.
I want to get to Camp Lejeune because that's really caught my eye. But before I do that, Jose was born in Spain, came over to the U.S. when he was 19?
17.
17. His mom worked for the Department of Defense. His father was a Spanish national. College in Boston, law school, Connecticut, JAG, Fort Bragg. That's the 18th Airborne. Which we went through in his resume. Special assistant, Shipman and Goldwyn, prestigious, very prestigious, highly recognized law firm in Connecticut. They've sued just about everybody. And now he's in his own business. But when did you know you wanted to be an attorney? Did you know early on?
I did. Yeah.
How old were you?
I think I was maybe 8 or 9 years old.
Really?
Yeah. And what's amazing and how you come full circle is I went to school on a military base, Torrejon Air Force Base, right outside of Madrid. And I remember a JAG. I have a distinct memory of a JAG officer coming to my school on like a career day and talking to us. And I remember him saying, don't go to school for the money. Don't go to law school for the money because the student loans are so high. You know, you don't do it for that reason. And I just always had from very early on, I had this sense of justice that I always wanted to correct.
Did you like to argue?
I always like to argue, but I always like to find the guy that was being picked on and take his side.
You arguing with your wife?
I learned not to do that anymore.
Well, hopefully, you're throwing me now. Jose has got a beautiful wife who's got a very interesting story to tell. Hopefully, we can get to that before we get away from here, because that's a good story. In addition to what you're going to tell us today, let's get to Camp Lejeune, because that has national significance. Who would believe that these happen in our military bases where we're poisoning our guys and killing our guys? Tell us a little bit about that, how you got involved with that. And where are we today? Because we see it, it's advertised on TV all the time, but we really don't know the specifics of it. Can you fill us in on what's going on?
I'd love to. I think it's one of the most important litigations in the country right now. I'm saddened to see so much advertising for it, because a lot of the firms that advertise are not real litigators. They're not real trial lawyers. They're just trying to accumulate cases. But notwithstanding that, what I am very happy about is that these veterans that served our country are finally being properly taken care of. And I want to explain a little bit. So, as you know, as you've said, I'm a veteran. I have a special place in my heart for anyone who serves this great country. And so I really feel that this is potentially one of the causes of my career, to be able to do something for the folks that have served our country so bravely. The Marine Corps slogan is Semper Fidelis, Semper Fi, and that means always loyal. And these Marines were loyal to their country. They served, many of them leaving their families to go die for the country. Many coming back with severe injuries and mental health issues. And they indeed were loyal to us. And for many years, the problem was that we were not loyal back. And that's a damn shame.
That seems to be always the case, though.
I think our veterans are not treated with the loyalty that they deserve, the loyalty that they gave us. And so Camp Lejeune is a good example of it. What was happening at Camp Lejeune was there was these chemicals that were being leaked into the water, and they're highly toxic. And it looks like, yeah, we have as you can see on the slide. So it was TCE and PCE, which is used in two main ways on and near military bases. One, you see it in laundries, which military bases have. They're a dime a dozen. Anyone who's been in the military, you constantly got to bring in your uniforms to make sure they're the way they're expected to be, which is sharp. And so these laundry services are very present on military bases. But the other thing that was present was all the machinery, the gunk from the oil that would clog up would need to be washed away and cleaned up. And that's where TCE came in. Both are highly, highly toxic. And have been shown to cause very serious disease. This is something that happened from roughly the 50s to 1987, 1953 to 1987. It was leaking into the soil. It was being dumped and getting into the water sources at Camp Lejeune. I spent a lot of time. I was at Fort Bragg, so I was just right down the road. So I spent a lot of time at Camp Lejeune, not during this time frame, but I spent a lot of time at that installation, and the soldiers and the Marines and their families that were there were being exposed to this. And what they started seeing in the 50s and 60s and even into the 70s was horrific things. You were having babies being born with very serious defects, with half a brain lobe missing, with no lungs, with spinal disorders. And what they started to notice was a very odd cluster of very unusual things just even from birth. And then they started finding that there was a cluster of cancers that were coming out of the Camp Lejeune area. And at that time, it was really not understood why. But what we've learned since then was that in Camp Lejeune, again, beginning roughly in 1953, this stuff was basically just being dumped and making its way into the water sources. And so in the late 70s, the government actually started taking a more active role in the quality of our water and started doing things like inspecting water sources and taking a bigger interest in making sure what we were drinking was safe. And what happened, which is what sadly we see in so many of these mass torts, is a cover-up. In 1980, 1981, 1982, Camp Lejeune folks became aware that the water was seriously contaminated. Reports have been uncovered that were delivered to the leadership at Camp Lejeune about the very severe contaminated nature of the water, and nothing was done. It is just outrageous that we were allowing our Marines and their families to drink this stuff when we actually knew how contaminated it was. And so eventually something was done about it, but it wasn't until almost, I think it was 1989, that finally something was done. And then the problem became, well, veterans have VA benefits, so they get something from that, but you had all these families that had suffered, the contaminated nature of the water and had developed cancers and other horrific diseases, and you couldn't do anything about it.
Why?
Because the government is immune. So sovereign immunity is a concept in the law where you basically can't sue the government. And so there was a lawyer down in North Carolina, Ed Bell. He's a friend of mine. He started this litigation. He litigated for years and lost and just kept losing and couldn't find a way to bring justice to Marines and their families. And what sort of changed things, I think we have a slide maybe. It's actually the third slide. We'll get to that in a sec. But what changed things was there was a federal legislation that was enacted that did two really important things from my standpoint. Number one, it waived sovereign immunity. So it created a means by which folks could pursue damages that they could prove. And it established a fund that was funded by the government to pay these folks. So that essentially is the Camp Lejeune litigation. The other thing that was accomplished in that legislation, which is really unheard of, in my 25-year career, I've never seen anything like this. Normally, you have to prove not only that there was a bad thing done, so in this case, it's toxins being dumped into water sources, but you have to prove that that damaged someone. A normal legal case, you have to prove, more likely than not, that that toxin caused a particular condition. That makes sense, right? So, if we're saying that, tobacco as a general proposition causes lung cancer, you then have to prove that in that particular case, the lung cancer was indeed caused by the tobacco, just borrowing from another type of litigation. Here, the difficulty was going to be, how do you prove that, if someone has, and I listed, we have there, can we bring up the, what are the injuries? The third slide. Well, anyway, there's a series of cancers that are caused, that we know are presumptively caused by the toxicity in the water in Camp Lejeune. And so there's a list of some of the very common conditions that have been associated with the toxic water in Camp Lejeune. But what the legislation did, which I think is really important, is it doesn't force us to prove that a particular cancer was actually indeed caused by the water, but only that it's essentially plausible that it might have been caused by the water. That is a very generous thing that the government gave these folks. It doesn't exist in any other type of litigation. We generally have to prove that it's more likely than not that the condition caused the effects.
How many people are we talking about that would be affected by this?
You know, it's hard to say, but we think there's probably about 1 million that are affected. I mean, it's a big time frame. You're talking anyone that was on the installation, and it can be a civilian or a service member, from 1953 to the end of 1987, so essentially 1988. Those are the folks that are going to be eligible. If you can establish that you were on the installation for a period of at least 30 days between 1953 and December of 1987, that's the criteria that's going to make you eligible for a Camp Lejeune claim. If you have any of those presumptive illnesses that we put up earlier, then you're probably going to have a pretty strong case.
Where are we in the litigation process at this point in time?
So the bill was passed many months ago now and signed into law by President Biden. It is the law of the land. And now that the process is we're just filing the claims in North Carolina. There's a federal judge that's been appointed there. And those claims are being processed through the JAG, actually. You have to file an initial claim, and then eventually you file the lawsuit in the U.S. District Court in the Eastern District of North Carolina, which, by the way, is where I was a federal prosecutor.
And what is the function of 11 ROJAS, Camisar, and REC with regard to this problem?
So what we're doing is we're taking on clients all over the country, really, but the majority of our clients are from Connecticut, and we do the intake. We make sure that the case meets the criteria, that it actually has all the things that we need, that you were there for 30 days, or the family member was there for 30 days, that the disease at issue is one of the ones that's recoverable. We get the necessary medical records that we're going to need to support the litigation, and then there's a claim that needs to be filed, and we file that claim on the client's behalf. And
when do you think it will get to the judge and jury?
So some of these will not even get to the judge because the government may, once we file the claim, it's possible that the true answer is none of us know, because this is the first time, and this has never happened before. It's essentially the government has set up a claims process, and what we don't know is how scrutinizing they're going to be. Are they going to want to just take the claim in and then create a compensation tiering system that makes it relatively easy, or are they going to want us to litigate, some of these issues? We just don't know yet.
Who makes that call?
So that's going to be a combination between the JAG Corps involved, and the Department of Justice will certainly have a role, and possibly the judge. But they're gonna have to make those decisions, and then nobody knows because it hasn't happened yet.
Yeah, but when you say they, who is
the government? It's the federal government.
And what level of government is making that decision?
Pretty high. It's it's going to be lawyers, that are involved either in the.
That's what worries me.
It does me too. But I also think that the law, as it was drafted, is very, very favorable. I think I'd rather deal with the government on this because they're sensitive to the political pressures of not wanting to hurt our service members than I would be dealing with corporations who are truly without either political sensitivity. There's only one thing they care about, which is profit.
What's the average age of your client involved in this legislation or litigation?
Yeah, they're going to be older, just because you're looking at they would have had to have been on Camp Lejeune from 1953 to 1987. So for the most part, it's going to be folks that are retired by this point. So from the military or their spouses and family members. I mean, kids were affected, so kids may have claims too. So it's going to be quite a range. I'd say if there's a nucleus of kind of an age group, it's going to be, folks certainly older than 60, I'd say.
And Jose, Is the word out there? Has there been enough publicity on this that the guys and the ladies who are involved with this, they know what's going on?
I think the publicity has been so extensive that in some ways it's been counterproductive in my opinion, because it's the lawyers have been so aggressive about advertising for it that I think it's getting, you know, a little bit of a stigma, you know, of being just ambulance chasing lawyers going after stuff when indeed this is really important litigation. But I do think that it's really critical that when people decide to get a lawyer, that they hire someone that actually handles trial work and litigation, rather than some of these lawyers that you see advertising on TV that literally what they'll do is they'll take the case in, it sits in a warehouse in inventory, and then they hope for a settlement someday. You don't want to be that guy. You want to be at a firm that actually is going to file the claims, file the lawsuits, litigate as needed, make sure all the things that need to be done, like getting your medical records, your full medical records, is done so that claim can be really properly presented to the folks that are deciding.
Is there anything else that you want to cover with regard to the Camp Lejeune?
You know, just a little side story. So there's an interesting, we're filming here right near New London, and the connection to Camp Lejeune and the Marines of this town is something that I just over the weekend I was doing some reading, and I think is really, really, really curious. So the Marines have an interesting origin in a certain way right here in New London. And that's because in 1910, when the Marines were really trying to figure out what their role was going to be, whether they were going to get subsumed into the Army, whether the Navy was going to, you know, keep them, or whether it'd become a whole separate branch, the Navy had a real interest in making sure that the role of the Marines was clearly defined. And essentially what they created was an advanced base school right here in New London, Connecticut in 1910. And that advanced base school is essentially what the Marines do, which is, or at least how their role has been defined as unique from the armies for many years, which is they go into, you know, foreign areas, they take over, they land, take over an area, set up a base, and then defend the base so that the rest of our forces can come in larger numbers. So I was really curious to find that, and it's washed away in history because they were only here for 1 year. They were here from 1910 to 1911, and then they got moved to Philadelphia, and that same school then got eventually moved to Newport. But it really became, it is what the Marines essentially are, and we have an interesting little historical connection right here.
Yeah, it's very interesting.
Yeah.
So as I mentioned, your resume mentioned, you were appointed as a national lead counsel in mass tort for the infant formula litigation. I don't remember anything about that. What's that all about?
Yeah, so that litigation involves premature infants, and premature infants are a particularly vulnerable population. Their immune system is not fully developed, and they don't have the ability to defend themselves from toxins the way that a full-term infant is. And so what happened was my partner, Steve Reck, a few years back, he had a woman who called him up, and she said, you know, my baby, I believe, was died because of infant formula that the baby was fed at Yale New Haven Hospital. And my partner said, that can't be. It's impossible. How could infant formula cause a baby to die? And so obviously the initial reaction was a little suspicious, and yet Steve and I started sinking our teeth into the medical literature out there. And what we found was that premature infants, when they're fed cow's milk formula, are many, many times increased risk of developing a horrible disease called necrotizing enterocolitis. I think we have a slide that we brought that shows, yeah, so basically what happens is, and you see in the slide there that it's an inflammation of the intestinal wall, and essentially what will happen to these poor babies is a third of them will die, and a third of them they need surgery where most of their intestine has to be removed, and they live a life of just horror. They get things like cerebral palsy. They have short gut syndrome. They have retinopathy of prematurity. They have all kinds of ailments that afflict them for the rest of their lives. And what the studies were showing is that when premature infants are fed an exclusive human milk diet, for the most part, they don't get these horrible diseases. And we see that. I think if we can show the next slide, what you saw is that eventually the American Academy of Pediatrics said that premature infants should be fed an exclusive human milk diet. Let's see. That's just some of the statistics. You see one study showed a 4.2-fold increase when preemies are fed cow's milk. Another study showed 5.1-fold increase. You see there, one study showed that an exclusive human milk diet makes babies 90% less likely to develop this horrible disease. So eventually, like is often the case, what the science caught up, and the American Academy of Pediatrics said that premature infants should be fed an exclusive human milk diet. And so what's happened is the formula industry has still continued to market its product for premature infants. And so we actually filed the very first lawsuit in the country on this. We filed the second lawsuit in the country, and the third, and the fourth, and the fifth. And at some point after we were filing these cases, the rest of the mass tort industry, the big lawyers, the ones that are really involved in this stuff, fly around in jets, they saw what we were doing, they copied us, and they started filing hundreds and hundreds of claims across the country.
Now, this started in 2022?
So that's when it became an MDL. We were actually litigating this all throughout 2020, 2021, and we were fighting the fight by ourselves at that point. Eventually, when the other lawyers started getting involved, there was an MDL that was filed, and it was consolidated under Judge Rebecca Pallmeyer, and now it's under that sort of umbrella that I talked about.
So what do you do what does a lead guy do? What's the function? And it sounds like a powerful position.
Yeah, I mean, we have, so there's law firms from all over the country that are brought into the litigation, and as the lead, we do just that. We lead the litigation. There's about 150 lawyers.
Now, you lead the litigation in the US of A?
Yes. Yeah, so myself, and I have 4 other leads that are my co-leads. There's 5 of us. And then there's a whole almost like a military structure below of all the lawyers. So there's about, I think at last count, there was about 150 lawyers working on this case
and right now,
for the plaintiffs.
Right now, your work is mostly paperwork.
Well, I got to go to court. I go to Chicago with some frequency to meet with the judge. We've been doing document reviews. So and I mentioned it earlier. One of the things that we always learn from these cases, every single case I've ever worked on, is once we start getting the documents from the company, what we find out is the companies knew forever. They knew forever that there was a danger here, but they're making so much money that they don't want to take it off the market. And in the case of preemie formula, they particularly love preemie formula, the companies, because they find that the earlier that the product is delivered to the baby, there'll be brand loyalty to that product throughout that baby's life. So they know exactly how much money they make. You know, if you can get the child in the hospital, they're likely to continue to consume that exact product. So that's how they get market share.
Are they still making it?
They're still making it.
How could that possibly be?
You know, when they've done something like this and they get caught, they have to defend themselves. You know, and they have to, if they pull the product off the market, suddenly then it's almost an admission of guilt, and they're still in the middle of a litigation. So they just keep defending it, even though it's indefensible. And what you see is slow, steady change. So what we've seen since we filed the very first lawsuit against Yale New Haven Hospital, it began as a medical malpractice case, is the hospitals themselves, the medical industry, is what's pushing back now. And so they've stopped feeding babies formula for the most part. Some hospitals still do. And now what they're trying to do is they're trying to mix donor milk with what they call fortifier, which is something that it's still cow's milk formula, but they now mix it with human milk. And we do find that's less of a risk, but it's still an increased risk. The best solution for anyone who's a low birth weight infant, prematurely born infant, is to have exclusive human milk diet, which can be accomplished. The science is already there for it. Even if mom is not lactating, they have donor milk now that's available, and that can be fortified with a purely human milk derived fortifier. You know what's amazing? You know what Abbott and Mead call their fortifier?
No idea.
Human milk fortifier.
That's a good word for it.
Guess what? It's not human milk. It's cow's milk. I mean, they just have zero shame. You know, there are so many parents that believe that human milk fortifier is just that, human milk, and it's not. It doesn't have an ounce of human milk in it. It's cow's milk.
So, in litigation, somebody's going to win, somebody's going to lose. Is it the insurance company? You mentioned Yale New Haven. Is it the insurance company that's going to lose, or is it Yale New Haven's going to lose? And what part is the insurance company take with regard to the litigation? They have to be involved somehow, because they're going to pay the bill, I imagine.
Yeah, so insurance may be involved. You know, the two main defendants that we're going after is Abbott Laboratories and Mead Johnson. And these are large cap corporations. Mead Johnson's owned by a foreign conglomerate called Reckitt. They're fully capable of paying judgments themselves. They're likely, although I don't know this for a fact, they're likely insured for part of their risk. So the way these companies operate is they insure risk so that they don't have to eat it all. So I don't know that yet, but my guess is that they're at least partially insured. Insurance may kick in. The hospitals really, we've decided, are not the main targets here. The doctors, I think, the doctors were misled by the formula industry through studies that were done that were funded by the formula industry, through different boondoggles that were set up, through assurances that their products were safe. Our real target is shifted away from doctors and hospitals to who we think is really at fault here, truly at fault, which is the formula industry, because we know that they've known for decades that these little babies are at significant increased risk of harm through the use of their product. And I want to make clear, we're not going after the formula industry as a whole. We think formula plays a role. You know, some moms need formula, working moms, etc. This is something that only has to do with prematurely born infants who are particularly susceptible and vulnerable to these products.
Why is this litigation so important to you, Jose?
You know, to me, this litigation is really about protecting the most vulnerable. You know, the babies here are literally the most vulnerable members of our society. Not only are they babies, but they're prematurely born infants. They don't have immune systems that can defend them against these products, and it's really comes down to why I think mass tort as a general proposition is what I've decided to dedicate my career to in more recent years. And it's because I fundamentally believe that through these litigations, we can make change. We can effectuate change. I've already seen it in the infant formula litigation. There's no doubt that when I started this a couple years ago with my partner, Steve Rack, the hospitals were feeding formula all over the country. And we already have seen a major change. And I truly believe it's because of the efforts of lawyers who believe in the cause, which is a righteous one. And, you know, it takes me all the way back to when I was 8 or 9 years old, and you asked me why I wanted to be a lawyer. That's why. You know, I've always felt a need, a desire, a fulfillment when I help people that can't help themselves get to a better place. And that's why this litigation is so important to me.
What other litigation are you involved with? What are the other products?
Sure. I mean, we're involved in just about every mass tort out there. We're currently developing a new one called erythritol, which is, that's not in litigation yet. It's one that we're looking at. We're talking to experts about it. But erythritol is a sweetener that is used in a lot of products. The Truvia is one of the products that has erythritol. But a lot of artificial sweeteners have erythritol in the product. And erythritol, a study just came out that shows that they believe, the authors of that study believe that it causes clots. And therefore they've seen a significant increased risk of developing stroke and heart attack for people who use.
From an artificial sweetener?
Yeah.
That goes back as far as sweet and low, right?
Yeah, so they're different products. So there was one that years ago was thought to maybe cause cancer. I think that was largely disproven. Erythritol is something that has become more in fashion more recently. It's promoted as being organic. It's not. It's a man-made compound. And so the recent study that just came out, and it is a new study, has shown this dramatic increase in risk of stroke and heart attack. The question now becomes, is it going to be the story we've seen in other cases? Will we now find that when we look at documents from the company, internal documents, are we going to find out that they've actually known for years? That's the mystery that still needs to be solved. But if we do file this case, you can rest assured we're going to find out the answer to that question. So that's sort of hot off the press. No firm in the country has filed a case yet, to my knowledge. But we are looking to possibly do it if we believe the science is solid, if we think we can get through the Daubert that I talked about earlier, summary judgment, all the judicial gatekeeping functions, and we believe the science is good, we're going to pursue those cases as well. Beyond that, any of the big cases you've heard of, the hair straightener litigation,
I tried it. Look what happened. Unfortunately, we only have 5 minutes left. Is there anything else you wanted to touch on before I hit you with some questions?
No, I appreciate the time to talk about this stuff.
So, one thing Jose mentioned to me that usually I ask very boring questions. He said he didn't mind answering some questions off the cuff, and I got a couple for him. What's your take on gun control? It's a big issue in today's society.
Well, obviously we have strong roots in the Second Amendment in this country. It was there for a reason. But I think a lot of the reasons that really supported having guns in the regular citizenry don't really quite exist anymore. With that said, the Second Amendment is the Second Amendment. If the country wants to change our laws, which I think they should be changed, it has to happen through the proper procedure. The Second Amendment needs to be amended if that's what the country wants to do.
Amended to what? What do you think would be palatable? Because you're not going to take people's. Every time there's a terrible mass shooting, and it seems like they're more often than not. But every time you get these same people that want to take guns away, you're never going to take guns away from Americans. You might get some of them, but you're not going to get most of them. And I am convinced anyway.
Yeah, I think you're right.
Is there a solution to these problems?
I think there are some really sensible solutions that
I haven't heard one
that most Americans would actually agree with. I think most Americans would absolutely support background checks. Right?
Yeah.
So
I don't know who doesn't.
So why haven't we done that? Why did things get stalled in Washington? I think most Americans would support denying, people under a certain age access to military-style weapons. There's no real function for those in a civilized society. That's not taking away people's rights to bear arms, to go hunting, to engage in all the stuff that's very culturally connected to our country. And by the way, I do think that a lot of the sensible solutions would withstand Second Amendment scrutiny. If you had a reasonable basis, reasonable restrictions. It's like speech. Take speech. The First Amendment guarantees the right to free speech, but it doesn't guarantee you the right to stream fire in a crowded movie theater. Even rights have reasonable limitations that a civilized society can impose on those rights. There's always a pull between rights and the protection of society. I think here we have an opportunity to have some sensible measures that protect the populace, protect our children, while not unjustifiably or inappropriately restricting what is clearly a Second Amendment right in this country.
Immigration is a huge problem. We're more divided in this country now than we've ever been in my lifetime, I think. What's your position on that?
You know, we have to restrict the unlawful flow of people coming into this country.
Last year was a record.
Yeah, and so I think, again, I think most Americans believe that restrictions on illegal immigration are appropriate. At the same time, we have to balance that against the rights of humans. For example, one of the things that bothers me tremendously is that you can't kick out children who've been raised here. You know, you can't throw these kids out just because their parents brought them here illegally. I think it's one of these things where it's kind of like the jury system. If, you know, you ask me, do juries usually get it right? And I think they do. I really believe if you stuck 6 Americans, regular Americans, not politicians affected by special interest, but 6 regular Americans in a room on all these topics, whether it's gun control, immigration, and you put them in a room and you say, give us 5 solutions. I bet they could come out of the room in about 4 hours with solutions that the folks in Washington can't.
There's nothing of common sense value that's coming out of Congress these days, and it hasn't been for a while. You know, every year they meet and they kick the can down the road. Every single year it's the same bullshit, and they end up doing absolutely nothing. I'm disgusted with everything. Tell me about the death penalty. You favor it or not? I don't mean to put you on a hot seat here.
Yeah, no, I appreciate it. I as a former federal prosecutor, I don't believe in the death penalty. I don't think it accomplishes anything. You know, I think it lowers the nature of our civilized society. I don't think someone who commits crimes is going to be less likely to commit the crime because he's facing life in prison versus the death penalty. I don't think that factors in, you know. So the only thing I see that's positive about the death penalty is removing the burden of the expense from society having to you know, pay for their food and sustenance and everything else.
I wonder what Dr. Pettit would think.
I wonder.
We only got a couple minutes left. My daughter went to jury duty, and she came home. We argued about everything. Came home with the feeling that many people are convicted because of lack of good representation. Do you concur with that? And is that in case the fact?
I don't think there's any question that that's true. I mean, you know, O.J. Simpson was guilty, but he had really good lawyers. I think it's unfortunate that a lot of folks are convicted. I think for the most part, the justice system gets it right. You know, I as a former prosecutor, I can tell you that I didn't bring any cases that I didn't absolutely fundamentally believe in. I didn't have any agenda other than to try to get folks prosecuted that had committed crimes. So I think that's, for the most part, true. I think good quality prosecutors themselves are a gatekeeper towards people being prosecuted that are innocent. I think the conviction of innocent people is a relatively low thing. But it does happen, and oftentimes it is because of inadequate representation.
Last question, Jose. What do you see as the major issues confronting our country these days?
2. I think the first is polarization. We all sit and watch the news that we want to watch. Part of it's controlled by social media that is manipulating us. In other words, it's feeding us information that we know we're going to react to in a certain way. And what is happening in the process is we're all becoming more fixated in our positions, less willing to hear someone else's position and consider it. And this polarization process, I think, is a real danger to democracy. I think we need to stop. We all need to talk to each other more, listen to each other more, shut off the TV, shut off the social media, and go back to the old ways we used to talk about things. Bars, restaurants, town halls, those types of places. I think that will take us a very long way towards making this country greater. But if we don't do that, I think democracy is really at risk, because very much like the jury system, to get things done in a positive manner requires us to sit in a room, listen to each other, and come out of it sometimes with some level of compromise, but with good ideas.
What's the second?
So it's very connected. It's social media. I think is becoming very dangerous to our children. I'm very much against social media. I shut down, I was on the Facebook. I was wasting hours on there, and the Instagram, and I'm like, what am I doing? It's like, I'm not learning anything here. I'm just, and after a while, it just starts giving you the stuff you want to hear. So if you have a political position, it's feeding you that stuff that's going to make you angry about the other side. So they're intertwined, but I think social media beyond polarization has other real negative things that it's having on our children.
Attorney Jose Reyes, we are out of time. I don't mean to cut you short. And we didn't get to your wife's endeavors, but would you consider coming back on another time, and maybe you could bring your wife?
Sure.
'Cause that's a very interesting story you were telling us earlier. But I want to thank you for coming on the show.
Thank you for having me.
Very informative. Certainly a great guest. And thank you for watching. Murray I signing off from the city. Too tough to die in London.
All right.